Welcome to Frank Bruno Law. I am Frank Bruno. Today's topic, the ins and outs of the guardianship process in Supreme Court. Before I get to that, if you have any questions about guardianship, issues affecting our senior population, or elder law, please reach out to me, frankbrunolaw.com. It's my website. You could link to any of the public webinars that I'm giving. You can sign up for a newsletter. There's a few different giveaways, right? Information, 6 tips on this, 7 tips on getting through the probate process. A lot of information there. Plus, I have these videos. They're archived. So I have 2 different drop downs. One of which is the video itself, and then another one has transcripts of the video. So if you want to read what I'm saying, yeah. So the guardianship process. In New York, guardianship of an adult person based on an incapacity, based on an inability to act on their own behalf, takes one adult person applying to be the guardian of another adult person. The area of law is called the mental hygiene law, and that case takes place in the Supreme Court. Now, this morning I had a Article 81 guardianship appearance. Everything goes through the Microsoft Teams platform. We get a link, the judge, the law secretary, that's the lawyer that works for the judge, the court clerk, and then attorneys on the various cases on the motion calendar are also there. So the court is conducting business. Things are in movement, in operation. The incapacitated are being taken care of. In Queens, there's 2 dedicated full-time judges. They have some assistance with a couple of other judges that have a different calendar, but come in and pinch hit or take a portion of the caseload. So if you have the need for a guardianship, we're up and running. The court is up and running. We can file for you. A guardianship proceeding does not end until a judge says it ends. Welcome to Frank Bruno Law. I'm a guardianship, elder law, and probate attorney. So a big part of my practice is getting court-appointed work in the area of guardianship. And I have a case that reached a certain point, and we had a court proceeding about it this week. I'll explain. There was an incapacitated person that was appointed a guardian. Now, the incapacitated person, after several years, passed away. The guardian had to prepare and submit to the court a final accounting, and the guardian did do that. However, when that was filed, it was submitted to the court just like you would submit say a tax return or any other document that needs to be filed. However, in Article 81, the mental hygiene law, a final accounting has to be filed by motion. Motion is a particular method to serve legal documents. People that had been involved in the case are required to get notice, and they need to get it by notice of motion. After filing the motion, after filing the final accounting, but before a motion could be filed, the guardian himself passed away. So the incapacitated person passed away, then the guardian submitted a final accounting, and then the guardian passed away. But the guardian had not had the time to, I don't know if it was time or inclination, or just ran out of time to file the final account by motion. So the matter still remains open in the eyes of the court. There's still some money in the guardianship account that the guardian has to get to heirs of the incapacitated person. There may be some bills to pay. There's a bond that needs to be terminated at this point. So we need court permission to do all of that. So I was appointed referee in the case to hear, to review and report on the final accounting. So once I undertake that task and complete it and submit it to the court, then and only then, upon judicial decree, will the guardianship be terminated. If you have a guardianship proceeding, please reach out to frankbrunolaw.com.